We got to get another clock up there, although that clock is full board. Good.
All right, good morning, everybody, and thanks for being here. I want to just give you a reminder to go ahead and turn your cell phones to silent or off. And this meeting of the Escambia County Planning Board for July 1st is hereby called to order. Wow. With 9 members present, we do have a quorum, 100% attendance. So if you would, please join me standing for the Pledge of Allegiance. All right, thank you. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion to waive the reading of the legal advertisement.
Seconded.
Motion is second. All those in favor, please signify by raising your right hand. All those opposed, motion carries. Planning Board meeting minutes for June 3rd have been provided to the board. I'll entertain a motion to accept the Planning Board meeting minutes into evidence. Motion, do we have a second?
Second.
Second. All those in favor, please signify by raising your right hand. All right, motion carries. The Planning Board hearing package for July 1st, 2025 has been provided to the board members. I'll entertain a motion to accept the Planning Board hearing package and the legal advertisement into evidence. Do we have a motion? Do we have a second?
Second.
All right, motion is second. All those in favor, please signify by raising your right hand. All those opposed? All right, motion carries. All right, so today we've got a public hearing concerning the review of a development agreement for Skyline subdivision. And so we're going to take this and then we're going to jump over to our rezoning meeting and take care of 2 items on that agenda, and then we'll jump back into the regular planning board meeting and do the other 2 public hearings that we have today. So I will remind anybody that wants to speak, the pink forms are in the back of the room. And if you would just fill those out so we can make sure we get you called up here and turn them in here to the front desk. All right, our first hearing, a public hearing concerning the review of a development agreement for Skyline subdivision that the board review and recommend to the Board of County Commissioners, the BCC, for approval, a development agreement between S&S Acquisitions LLC and Escambia County for Skyline subdivision to vest certain conditions agreed to by both parties in accordance with procedures and requirements of Florida statutes. Would the applicant or their representative please come forward? I think that's a bit. Hey, Bill. All right, and if you would, just state your name and address for the record, and then we'll let you go ahead and make your presentation.
Sure. Name is Bill Mitchum. Address is 501 Convidencia, Pensacola, Florida, 32502. I'm counsel for the developer. And we are here proposing a development agreement for a 19.57 acre parcel on Bellevue Avenue. As I understand it, this parcel has been up for rezoning in front of this board and the county commission previously. Both times there was a concern over the stormwater drainage. The developer in this case has been working with the county staff to address that in two ways. Number one, and these are both in the development agreement and then in the PUD that we'll talk about a little bit later. But the development agreement limits the capacity, the density to 134 units. We will be requesting a rezoning from low density residential to medium density residential, which is 10 units per acre. Obviously, that's 190 units. So this is a 60 unit concession from the maximum density under the medium density residential category, which, you know, at 190 some odd units, that's probably a townhome development as opposed to a single family residential. So this is a single family residential subdivision. It's 134 units max. And so that's the first concession and the first item that's an item in the development agreement. The second, and maybe more importantly, the developer is agreeing to, in conjunction with their infrastructure improvements for the Skyline subdivision, which is our subdivision, expand the Rosewood Estates retention pond, allowing for additional stormwater storage capacity for Rosewood Estates so that it is capable of attenuating the runoff from a 100-year critical duration storm event. So when the Rosewood Estates pond was originally built, it was designed only for water quality treatment. But the new system, so combining our system with the Rosewood Estates, will provide both water quality treatment and flood attenuation. So that's a fairly large concession from the developer and something that staff recommended and that's now in the development agreement. Although not related to stormwater issue, traffic, you know, often is a conversation in these things, and just note that the Transportation and Traffic Operations has reviewed our application and provided a memo noting that TTO has no traffic capacity concerns related to Bellevue Avenue. Any questions?
Board, any questions at this time, or go ahead, Mr. Adams?
So, where is it located on Bellevue Avenue in relation to
I don't know if we have a,
Bellevue Elementary?
yep.
Did we have a
Muldoon and Bellevue.
Malden in Bellevue?
Yes, sir.
Okay. Oh, there we go. All right.
Yeah, just west of the fairgrounds, that's right. That helps.
Okay. Yeah, okay, I know where that is. Okay. It was going to be a church there at one time, I think, right? Yeah.
That's right.
Just wanted to see if we had any traffic,
Yep,
possible traffic
understood.
issues. Yeah.
Understood.
This parcel that's looking to be developed is roughly the same size as the Rosewood subdivision, correct? I mean, total.
It's 19, yeah, a little, almost 20 acres, yeah.
Total number of dwelling units in Rosewood is less than 60 right now, correct?
I think that's correct.
So this is roughly double.
That's
or
correct.
more than double.
That's
Okay.
correct.
Thank you.
Yep.
All right, any other questions at this time? All right, thanks, Bob. We'll, if we got more questions, we'll get you back up here.
Sounds great. Thank you very much.
All right, staff, if we could go ahead and have you make your presentation at this time, or we comments that you'd like to add from the staff side.
So I don't have a presentation. What I can do is answer any questions about development agreements and what rights they entail, should the board have questions.
All right. Board, any questions on the agreement that was provided in the agenda? Okay. All right, if we do, we'll come to you. So at this time, we will move on to public comment. I've got Mr. Hammond, the engineer of record. I don't know if you want to speak or not. We can skip over you unless there's questions. Mr. Sutton, we've got you as the agent, so good for now. All right, and then first public speaker is David Gibson. If you please come forward and state your name and address for the record, and we'll start your time.
Dave Gibson, 6008 Yellow Rose Drive, Pensacola, Florida. I live in the house that's right next to the catchment pond in Rosewood, and I'm speaking against this. This is the third time I've been here. I spoke to the zoning years ago when the church was trying to get it zoned. I was the only person that supported the church. And our concern is that the water has not been really addressed adequately. I had water out in front of my house about a foot deep this past Sunday. This is the third time in the last 6 weeks I've had water there. It's getting worse. Usually we have 2 to 3, 4 times a year at the most. This is in the last 6 weeks, 3 times. And to say you're going to put twice as many units on there is completely out of scope with what the other subdivisions are there. You got 60 units roughly in Rosewood, and you're talking about putting double on that, which means probably at the patio homes maybe, but even they can go up to 10 units, which would be 190 units. They've agreed on that, but that was the other thing I want to ask you about. Why wasn't a resident put on that board for the agreement? Why wasn't somebody from Rosewood put on that board to come up with the agreement with the developer? And so basically what's happening is we're getting railroaded. And what we're also fearing is what you've got over on Softly Field, right behind it, the units that were built on Blue Angel. You go down one street, turn, come down, and you got units built right up to the zoning limit of apartments with people on the second floor able to look into the backyards of these people who have privacy fences up and who can look right into their open windows if they want to. And so basically you've become a rubber stamp for the developers. You're going to give them what they want without any consideration of the neighborhood, any consideration of the other homes that are there in the area. We've got a major water problem. I will probably have to buy flood insurance now, even though the pond's going to be expanded, but all the water drains to my house out of Rosewood. The road is collapsing in front of my house. I didn't bring any pictures because I offered pictures last time. And so, I mean, it's you're doing a disservice to the residents there. And you could turn this down and you could send it back and you could do more, because there's a clause in the statement that says if there's an adverse, and I'm paraphrasing here, adverse considerations that need to be made, they can be made. But we're going to be helpless now. And I also would say, with the flooding that is there, if there's an emergency such as a fire or such as an ambulance, they will not go through. Thank you.
Thank you. Next, we have Mary Konopka. If you'll please come forward and state your name and address for the record, and we'll get your time started.
My name is Mary Konopka, 6248 Muldoon Road, Pensacola, and I've had dental surgery, so it's hard to talk. It may be hard to understand me. We ready? Okay. As far as the developer working with the county engineer on stormwater, this has been done over and over again in this county. First off, the county stormwater package that they use is 45 years old. Florida State has better standards. They have 2024 standards. Escambia County has 1979 standards, and it doesn't matter that developers work with engineering. I have a list, a small list, not the full list, of developments that the developers done it, gone, and the counties end up spending a lot of money fixing the stuff. Chris Kerb can tell you more about that. So I have no faith in the developer building a drainage system that's going to work for everybody. 30 years I've lived in that area, and the more building that happens, the more flooding I have. It has almost flooded out my business, my life, my income. I don't appreciate it. Horace Jones, he never tells you guys. You guys don't want to know anything. You say, haven't been there, haven't talked to anybody. You need to talk to people you need to see. And Horace Jones doesn't tell you that the LDC talks about current residents, negative impacts, their safety. Like Don Gibson said, when that water rises, emergency vehicles will not enter the only entrance to that neighborhood. And cars have been washed out, flooded out, trying to get in and out. The residents are stuck. I don't see where you can give us a 100% guarantee that the developer working with the county is going to remedy the flood issues, because the flood issues just aren't in Rosewood. They're down Muldoon Road. And Don did bring up something, and take no offense, but it appears to all of us, as you can see, a lot of you are in real estate. Is that why you approve everything? Is that why you approve? Is there a pot of gold at the end of the rainbow for you by approving this stuff? Because commercial stuff,
All right, thanks, Ms. Knopf.
You
That was your
disapproved.
time. Yes, ma'am. Next, we have Tina Lynn. If you'll please come forward and state your name and address, and we'll get your time started.
My name is Tina Lynn, and I live at 6813 Chicago Avenue. And I, too, repeat a lot of what Mary has said. I've lived in some of these neighborhoods. I've been in Pensacola for 35 years, more than that, actually. Paid taxes, county taxes, and I've had a lot of water issues, flooding in my own home and everything. With regards to this situation, it appears that it's just a resubmission of the same case, Z 2024-11, but with new agents. Same conditions still exist that should negate the approval of this rezoning. There's still massive flooding in the area after heavy rains. The drainage pond at Yellow Rose is still grossly inadequate. The county has still not come up with the estimated $20 million it will take to fix the Bellevue flooding problem by redesigning Hogan's Pond. Residents still have problems with both sewer and septic backing up in their yards and are immersed in water, and they can't even use the toilets with dignity and ease that toilets were designed for. The single entrance to the neighborhood floods so deeply it washes out cars, and anybody trying to navigate at this point, you can't, and if they're trying to go anywhere, they just end up flooded out and have no way to actually leave the neighborhood at this point. It's not an option. Emergency responder vehicles still will not enter the neighborhood when the entrance is flooded to a depth that reaches their bumpers. And again, Horace Jones still does not inform the board of the references in the LDC that refer to current residents' comfort, quality of life, and safety, or the detriment to the community that would negate upzoning in this area, which allows the planning board to disapprove the upzoning. The traffic counter is still located in an area that does not demonstrate the true traffic issues on Bellevue Avenue. The county is still using the 45-year-old drainage standards when the state of Florida uses the 2024 standards. Then, of course, the county wonders why they're saddled with so many drainage problems and they don't have the money to fix them. That's pretty much my sentiments.
Thank you very much. Next, I've got Chris Kerr. If you'll please come forward and state your name. And this was the last speaker that I had signed up for this this item on today's agenda. So if there was somebody else that thought they signed up, we'll get to you after Mr. Kerr goes. So I'll just make sure and check again. Okay, I saw a hand in the back, so we'll come to you, sir.
Good morning, Chris Kerr with Flood Defenders. I have a question about this development agreement. Will the Hogan Pit be expanded before this development is built or permitted?
I'd refer to staff.
We have some representatives, engineer, that maybe answer that.
Yeah, and Mr. Kerr, I'll say I do have some questions regarding the retaining pond, once we get everybody up here and speak, so, I will make sure to get some clarification on that for you, all right?
Well, I might be able to shed some light on it. The Hogan Pit is under capacity. It floods the properties around it.
Can you back up from the mic?
Excuse me.
Can you back up from the mic, because you become very muffled.
Muffled, okay.
Yes.
All right, the Hogan Pit is under capacity and needs to be expanded as represented in the Bayou Marcus Basin Study. Mr. Bluer has been flooding for 30 plus years from this Hogan Pit. Mary Konopka lives right next to it too. The plan calls for upgrading the pond, expanding the volume, and it calls for putting a drainage system on Bellevue Avenue that ties into a system that I actually put in years ago that goes down Hogan Road into the pit. The system on Bellevue is under capacity. By the way, the Rosewood subdivision met the 25-year design storm requirements of the county at the time. Not just water quality. So when these roads flood in Rosewood, might be because we're using a lower design standard. I have a handout that probably won't be able to get through it all. I'll wait till the rezoning part, but I'd like to pass this out.
Approach.
Chris, explain to us what this is exactly that you're letting us look at here.
First page is the Florida statutes, 2024 Florida statutes 339.157. And it references, in the red, you'll see some stuff that I've added on there referencing your land development code. Design Standard Manual, Chapter 1, Article 1, Section 1-1.2. If you look to the other side, that's also DOT standards for a pond and a closed basin.
Board, if you want to, I guess, accept this as part of the meeting package, I will entertain a motion. If not, we'll continue Mr. Kerb's time, but certainly let him address what he's given us here.
Mr. Chair, I think we should let him continue with his discussion, and if we need to, submit this to Joy, our engineer, or somebody else, and determine if we need to. I mean, I don't know that we're going to digest this in 30 seconds.
Okay.
I can make it real simple.
All right, we'll take it.
So the first page you're looking at is Florida Statutes 339.157. That statute was actually put into place in 2022 by the state legislation, thanks to the American Flood Coalition, to push flood resilience in Florida. What DOT had been doing for 6 years is referencing 2 rainfall data sources in their design standards. One is NOAA Atlas 14, and the other is their 1979 rainfall data, which is what Escambia County allows use of for design. If you'll see, there's 2 little charts on there. One is the FDOT 1979 data that has been archived by DOT in their 2024 drainage manual. You'll see next to it is archive, and it says not for use in design.
If you'll add another 30 seconds, so we're stopping and starting with Mr. Kerb, and I just want to make sure he gets ample time. All right.
I appreciate that. On the other page is FDOT design standards for closed basins. Hogan's Pit is a closed basin. When it overflows and fills up, it floods the properties around it. Escambia County has a basin study done on it, recently updated. You're looking at $20 to $30 million to give this pond an outfall. That's a lot of money. Oh, it's going to pick up 2 other county ponds that don't have an outfall either, and the county don't have the money for it. So if you increase the density, I'll finish. If you increase the density of this property, you're in effect increasing the flooding problem. Now, they have a right to develop there, but your design standards in your land development code are a lie.
Okay. Thank you, Mr.
Because if it says 100-year 24-hour design storm, then it needs to be a 124-hour design storm.
Thanks, Mr. Kerb.
Thank you.
Appreciate it.
Excuse me, Board. If a citizen offers opinions on technical planning matters, the Board must first determine by vote whether the individual is qualified to offer expert testimony on that specific topic. I would suggest the Board do so.
We previously qualified the speaker, I believe, actually twice in this board, I can't remember.
So,
For this action, we need to do it.
For this action, I'd
Because
suggest
it's
doing
in
it
this meeting.
on a
Right.
specific topic.
Yeah, I'm just saying
too.
previously qualified, so.
so if the board would like to do so, qualify Mr. Kerb as an expert witness, we certainly can, and I'll accept any motion that anybody would like to make, and or if there are questions for Mr. Kerb before doing so, you certainly are able to do that, or if not, we can continue to move on.
Motion to accept as an expert.
Second.
Is there any discussion? Okay, all those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. I did see that somebody else wanted to speak on the agreement from the public. Did
There
we
should
still
be a
have
couple
anybody
more.
from the public that wanted to speak?
Yeah, there should be a couple more speakers that I handed to him.
I don't know that I had them marked for the agreement itself, so I've got for multiple other items today, but I didn't see for the agreement. Yes, sir.
Good morning, Tom Hammond, Hammond Engineering, 3802 North S Street. I'd like to be qualified as an expert witness.
Yes, sir.
Motion to qualify Mr. Hammond as an expert witness.
Got a motion, a second. He is the engineer of record for the PUD. Any discussion on the motion and second? Seeing none, all those in favor, please signify by raising your hand. All those opposed, okay, motion carries. Mr. Hammond.
Thank you. You know, a PUD, I've done a bunch of PUDs, and back in the day, a PUD was where we asked for a variance to zoning regulation, and then we offered something that wasn't required, like sidewalks and lighting and that type of thing. Well, in this situation we're in today, I think a PUD makes a lot more sense when you actually offer something that's good for the public outside your project. And that's what's happening here. You just heard the people get up here and speak about existing conditions. Water up to their door, bumpers, fire people can't get in there. You heard it from their own words. this project is asking for a variance for building the lot widths, but in turn, we're helping and partnering with the county to fix an existing stormwater problem. Can y'all put the aerial photograph up there of existing conditions? And then follow that up with a plan view that shows our grading plan, please. You can see that little square at the southeast corner of Rosewood? That's the stormwater pond today. You can put the other plan up there for me? You can see that massive stormwater pond. It's like 10 foot deep. When I designed this pond, I backed up and went backwards to see when Rosewood was developed. It's developed between 94 and 98 based on Google Maps, because it's there in 98 and it isn't in 94. And I treated it as if it wasn't there when I did this design. So the pre-development rate was from 1994 when there was no subdivision. You take that into account, and then you build both them projects out to today, and that's the difference in runoff from all that impervious from when there was zero impervious. And we're doing that with this pond and still releasing it with less runoff than would be there pre-development 1994. So this is a documented flooding area, and we're addressing it and partnering with the county on addressing the attenuation. And also, if you read through Ms. Blackman's statement, there's other things happening along Bellevue to get this water out of the Bellevue Road. Thank you.
Thank you. Are there any questions from the board for Mr. Hammond?
I was going to ask Mr. Hammond, Ms. Blackman, given the emotions of people that live there, I get it. You know, they have a problem. We've had a problem. I've been up here before. I've been part of an actual development where we built a condominium nobody wanted, and it solved the problems of that neighborhood because we had to pay for the design of exactly what you're doing now. It worked out well. That was great. Nobody talks about it after the fact. They do talk about the problems, the shortfalls, the fact we don't have any money, that a problem that was created. How, Mr. Hammond, I'll ask your suggestion first. When you build something like this, how do you hand off this issue, this pond, to an HOA and help them maintain it? Because historically, you do our design, we build it, see you later. And then later, Horace and them got to catch the arrows for the fact that they have never maintained it, they've never cleared it out. Over 10 years it's built up, it's nowhere near the capacity it used to be. How do you maintain these things so that they work? And is it your opinion, as an expert, that this is going to improve what is existing already, a problem that exists? I don't know if you know, I don't know to the extent of how bad it is. These folks have obviously expressed it. Ms. Blackman, do you feel this is going to help solve your problems? Because you know they're going to be back at your door in 5-10 years.
I'm sorry. Thank you. Good morning. I'm going to assume you've all read the statement in the background or my memo to the staff from the staff review. In any design, one of the best places to start is upstream from the problem. Our bigger problems are at Hogan's Pit. We're going to be upstream of the Hogan's Pit here, and this problem, you know, is in and of itself a poor design from 1990 whatever. And my assumption with the timeline of that design was that it was only for water quality. Is that's the subdivision was minimum standard at the time, and Chris says that it's 25-year. Either way, it's still not adequate. It's below minimum standards of today. So the best way to work the problem is resolve the problem upstream of where you have flooding. Well, in this case, we're going to start exactly where the flooding is existing in the subdivision and have them redesign as if it never existed and we're designing for 2 subdivisions at once. So when Tom mentions it's pre-development to what we're asking for is pre-development to the extent that Rosewood doesn't exist today, and you're developing Rosewood and, what is it, Skyline? You're developing them both to today's standard. Chris will argue the standard is not the same as DOT's, but the minimum standard that the board approves is what's in our code. So we're above and beyond the minimum standard for Skyline by addressing the problem in Rosewood. What we'll also have in this design is a better outfall for both subdivisions, as well as trying to resolve some problems upstream of there, which is Zachary. And you've heard that conversation before from Mr. Bluer. Those were also designed in an earlier day. So we're trying to accommodate old issues by correcting them with a new development. Downstream of this development, Bellevue Road had some flooding. We're going to have that crossing upgraded. We haven't modeled all these things yet, but that's the commitment we're getting. We're going to look at the model and make sure that we can minimize or eliminate completely any flooding or road topping on Bellevue. Upgrading the design down Muldoon that Chris previously did some work with, upgrading that, tying into the easement we have for Hogan's and allowing for inlets to take the water on from the neighboring property, so hopefully minimizing and hopefully eliminating that flooding too. Hogan's Pit is in design for an outfall. We are trying to expand it. We've got some environmental concerns that are being reviewed at this time. They're being assessed, I should say, at this time. We started some expansion work and ran into some problems with trying to just expand it because we're not sure if there was something buried there in the past or what have you. You know, it's just an older area that might have been filled in with some things that shouldn't be in the ground anymore. So we're trying to work through all of those issues at the same time. That project's ongoing. Mott MacDonald is under contract to reevaluate the original design that Chris speaks to of $20 million. We're not trying to build that design. It's not constructible. It's just not possible. I will have to come up with other ideas, and they're working through that with county properties. So we're working upstream, Zachary. We're working Rosewood with this project, and working for improvements along Muldoon and for the neighboring property to Hogan's Pit. And then the county's is already working downstream of that for Hogan's Pit outfall. Defining it as a closed basin is a little strong, but I understand why. It is in quotations closed because without an outfall, you really are closed. It does outfall through properties, which it's not the answer we want. So for all those things, those are true statements, not the DOT standard, exceeds the county's minimum requirements over and above with the requirements that we're putting on them now, and doing everything we can find in the process to improve anything downstream of that as we go. So the county we do have some funds set aside for this area, and that's what we want to put the money into, is getting this resolved. Most of the expense towards this, without getting any details, because I don't have estimates yet, because I don't have a model, but our agreement is the county would provide the materials, if you will, for the crossing at Bellevue. They'll provide everything else for the work that they need to do on their own properties, and the expansion of the Rosewood Pond. The county will be maintaining those ponds.
Just to confirm, Escambia County is fully getting this through dedication for the 1.33 acres and the 0.62 acres for these ponds. As long as the county's got a plan for it, that's a big thing, so.
Just taking it back to Mr. Pyle's question, you're right, when it's private development, HOA, I mean, as the engineer record, we give them maintenance plans required by the state and the county, but how to enforce making that happen when it's private, that's a good question. When it's public, which developers like it to be public, that's why, because then you got a maintenance entity that's gonna take care of it.
My apologies, Mr. Powell. Since my recent tenure here with the county, we've not really allowed any other private ponds if we can avoid it at all costs. There was a requirement in the code that said if you had to do 100-year on-site retention with no discharge, then you had to make it remain private. We took that requirement out recently in our work, and we're not requiring that any longer. It's my experience that if it's private, eventually it's going to be the county's to maintain. So we try to go ahead and accept them. And those that are private today, there's a process for transferring them to the county, and we do everything we can to make that work out. And Perdido Estates is a fine example of that, because it was designed back when Chris was reviewing plans, and none of that works. And even though they can't bring it to county standard, we know that it's to the public benefit and public safety benefit to maintain it, so we're taking it over. There's a process. Anybody get involved with homeowners associations, feel free to contact our office, and we'll help you work through that. Thank you for asking that.
Just to confirm, both Zachary and the other one, Rosewood, are both county-owned ponds and county-maintained ponds currently, correct?
Mm-hmm.
Okay, I just want to, they're not private. I just
are.
want to make sure that, everybody understands they're not private. Those are county-maintained ponds.
Yes, sir.
Okay.
All right, any further questions? Mr. Hammond, I did have a question here on the 20-foot drainage here on what it would be, I guess, the west side of the property. So that's a 20-foot buffer that's allowing for the water to collect and then go down to the pond. Is that what I'm seeing there, in a 20-foot buffer from
Yes,
the
sir.
neighboring
So there
neighborhood?
is water off-site coming from Rosewood backyards and that type of thing, off-site water, and we've got that easement there to figure out how to convey that water to our system.
Okay. All right, thanks.
Yes, sir.
All right. Is there anything else that we've got from staff or from the applicant on this agreement? Okay, if not, board, I will entertain a motion one way or the other, and I will let you know if you're to make a motion to approve the agreement. It needs to be contingent upon the rezoning case that would be later in the meeting today. And so that would need to be included into a motion if you decided to make a positive motion here for the development agreement.
Chairman, I don't mean
Yes,
to
ma'am.
interrupt, but the gentleman in the back wanted to still speak on the
Oh,
development
I'm
agreement.
so sorry. If you, please come forward and just state your name and address for the record, and my apologies.
Sorry to interrupt your the business.
You're good.
It's Joshua Zeller, 6506 Lake Charlene Drive, Pensacola, Florida. So I'm for the project. To be completely transparent, I am part of the church that is looking to sell the property. I know the concerns of the neighbors, and I've lived in that area. My parents still live in that area. So I know, like, for example, when you're driving down Mobile Highway and you go to 8 Mile Creek and you see the flooding, like I know that area has some issues. But at the same time, I think the best way or the only way many times to fix the issues is by bringing in new development, and like kind of what they were saying is to enforce new standards, new codes, to be able to fix some of those issues, because many times it's not probable for those issues to get fixed just out of the blue, just because it's passed in a budget or just because someone is allocating some money for it. So many times putting it on the developer is many times the best and the only option for actually addressing some of those issues. I know that they have concerns also about access to the neighborhood when there is flooding. Hopefully, with this, the flooding will be able to be mitigated or stopped totally. And with the development of that neighborhood, I know there's other access points that possibly could be added to the neighborhood. The other thing is kind of what they were saying, that it's going to be county maintained. Thank you. I know a lot of times, as far as residents, we especially I've been here since 01. I know some people have been here longer than I, and I know a lot of times we have the idea, well, let's just keep everything the way it was. But I think this is a county that is growing, and I think if the only way to have good growth is to fix some of the problems of the past. And with that growth also comes a lot more tax revenue from property taxes that will help maintain some of these things. So that's, like I said, that's my opinion. I'm for it, and thank you for letting me speak.
Thank you very much. All right, sorry, board, jumped ahead there, but that was our last speaker. So if there are no further questions, I will entertain a motion again. If you're bringing a motion that is for the approval of the agreement, it does need to be contingent on the approval of a later rezoning case. Or if there's discussion that the board would like to have, please.
I would also like to suggest that the motion contain, if it's for approval, a finding of consistency with the comp plan as well as the land development code.
Mr. Chair, I'd just like to encourage the citizens that came out that regardless of the outcome of this and or the other issue coming before us, that communication is pretty important, that you don't throw your hands up and say, oh, they're all realtors and they're in it for whatever. But I'm making light of that. But this board, I don't know of anyone here who would have any benefit whatsoever from this particular project. But I would say that you need to continue to communicate with the people at the county, whether you like them or don't like them. Sometimes, Horace wants to strangle me, and likewise, but I still come back because it's the entity that is responsible, as Ms. Blackman is sharing. And during the construction phase, if you can't hold hands with the developer, which I hope you can, and hopefully get more out of that development for your benefit, they're going to be gone at some point in time, and you need to be able to communicate with these folks that we still have a problem. I'm certain Ms. Blackman doesn't need any more people fussing about this. I know that it's not their desire to ruin your day. I can't see it changing with us doing nothing. If we did nothing, I don't think anything would change at all. And you've heard the commitment from the folks here at the county, and I believe Mr. Hammond, I don't know. It's an interesting issue today.
Am I allowed to question?
Well, you'll have some time to speak on some of the other items, but we have closed public comment, and the board's going to have a discussion now what they've learned. Board, any
I motion to accept this agreement.
All right, and I think if that's the motion that you're wanting to make, this county attorney has asked that it be, I'm going to let you repeat what the comment you gave us earlier, just so I don't mess it up.
Sure, any motion to approve should contain a finding of consistency with the local comprehensive plan and the land development code.
And contingent on the rezoning as well.
Correct, yes.
I'm not going to state everything you just stated, but I motion in agreement with Mr. Schaefer. Understood? Okay.
Okay. All right, so we do have a motion on the table. Is there a second to the motion?
I'll second.
Okay, is there discussion on the motion that we have on the floor? Seeing none. All in favor of the motion, please signify by raising your right hand. All those opposed, please raise your right hand. Okay, motion carries 5-2. At this time, we will move on to, we will close out for now the regular planning board meeting and move over to the rezoning meeting, which is hereby called to order. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
I'll entertain a motion with, to waive the reading
Motion.
of the legal advertisement.
Second.
All right, all those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. The rezoning meeting minutes from the previous board meeting dated June 3rd has been provided to the board. Were there any additions, deletions, or corrections? If not, I will entertain a motion to accept the meeting minutes into evidence. Do we have a motion?
So moved.
Second.
And a motion is second. All those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. All right. The rezoning hearing package for July 1st with findings of fact has been provided to the board members. I'll entertain a motion to accept the rezoning hearing package with findings of fact and legal advertisement into evidence. Do we have a motion?
So moved.
All those.
Second.
Second. All those in favor, please signify by raising your right hand. All those opposed? Okay, motion carries. Can I have the court reporter please swear in members of staff?
Join you. Sworn in just in case y'all have to speak again. Yeah.
All right, do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Do it fine.
Thank you. The board has previously qualified staff to offer expert testimony in the area of land use and planning. Do any of the board members have questions regarding their qualifications and ability to offer expert testimony? All right, seeing none. Okay, at this hearing, the planning board is acting under its authority to hear and make recommendations to the Board of County Commissioners, the PCC, on PUD and rezoning applications. These hearings are quasi-judicial in nature, and quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All testimony will be given under oath, and anyone testifying before the planning board may be subject to cross-examination. All documents and exhibits that the planning board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the planning board will consider the relevant testimony and exhibits entered into evidence and the law. Each individual who wishes to address the planning board must complete a speaker request form and submit it to the planning board clerk. These forms are on the table in the back of the boardroom, and you will not be allowed to speak until we receive a completed form. And please note that only individuals who are present and give testimony today will then be able to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented at the BCC meeting, therefore all testimony and evidence must be presented here today. The Planning Board will provide a recommendation for each PUD and rezoning request to the BCC, which will review testimony, documents, and exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of the decision of the BCC must do so in a court of competent jurisdiction within 30 days of the date the BCC approves or rejects the recommended order of the planning board. All written or oral communication outside of this hearing with the members of the planning board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution Number 96-13. As each case is heard, I will ask that any board member who has been involved in ex parte communication to identify themselves and describe the communication. As required by Section 2-6.8 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. The applicant has the burden of presenting competent, substantial evidence to the board that establishes each of the following conditions for the PUD. 1, creative planning. Uses and structures are arranged in a manner that demonstrates creative concepts of land use planning throughout the development area. Residential uses include a complementary and sustainable mix of dwelling unit types or mix with non-residential uses. 2, natural amenities, clustering, setbacks, easements, and other methods are utilized to preserve, to the greatest extent practicable, the natural amenities and characteristics of the land, including open space, topography, natural vegetation, groundwater recharge, waterways, and scenic views. Deficiency in natural amenities are supplemented through landscaping and other enhancements. 3, desirable environment. A more desirable environment in which to live or work is created than would be possible through the strict application of the minimum requirements of the LDC. Common open space is within reasonable walking distance of all dwelling units in the development. 4, mobility. Internal circulation systems promote both pedestrian and vehicular mobility, especially between residential areas and local public open space, schools, retail sales and services, and employment. Sidewalks are located on at least one of every street to support safe pedestrian mobility within the development and appropriate access to surrounding uses. 5, efficient land use. An efficient use of land results in smaller networks of streets and utilities. If street right-of-ways are proposed to be less than standard width, easements will provide adequate space to install and maintain utilities. 6, compatibility. The development is compatible with surrounding areas and provides stable conditions and character to maintain long-term compatibility. Then, as required by Section 2-7.2 of the Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following conditions. This is for, sorry guys. This is for the rezoning requirements, approval conditions. The applicant has the burden of presenting competent substantial evidence to the reviewing board, establishing that the requested zoning district would contribute to or result in a logical and orderly pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area required for mailed notification. A logically and orderly pattern shall require demonstration of each of the following conditions. A consistent with comprehensive plan. The proposed zoning is consistent with the future land use FLU category as prescribed in LDC Chapter 2 and with all other goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment transmitted for state agency review, the proposed zoning is consistent with the proposed FLU and conditional to its adoption. Consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning establishment provisions prescribed by the proposed district in Chapter 3. Compatible with surroundings. All the permitted uses of the proposed zoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with those surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the district compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the compatibility of specific residents or activities protected by fair housing law. D, appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of those mitigating characteristics or conditions demonstrates an appropriate site-specific balancing of interest between the isolated district and the adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of rezoning have changed, the changes are to such a degree in character that it is in the public interest to allow new uses, densities, or intensities in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to create or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, I will allow staff to briefly present the location and zoning maps, photos of the property. Next, we will hear from the applicant and any witnesses that they may wish to call. Then we will hear from staff and any witnesses they may wish to call. And finally, we'll hear from members of the public who have filled out a speaker request form. There are two cases to be heard today. The first case is a public hearing concerning the review of Skyline subdivision, a planned unit development or a PUD. That the board review the development plan for Skyline subdivision, a planned unit development, and confirm consistency of the plan with the Land Development Code, LDC, requirements prior to transmittal of a recommendation to the Board of County Commissioners to review and consider the plan for a final decision. Members of the board, have there been any ex parte communications between you and the applicant, of the applicant's agents, attorneys, or witnesses with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
No to all.
No to all.
No to all, but except a constituency in District 2 did reach out asking questions about the whole program for today. So,
Okay. No to all.
No to all.
No ex parte communication, but I have visited the site as recently as of today.
Okay.
No to all.
Familiar with the site, no to everything except for SNS Acquisition is a insurance client of mine, but there's no no prejudice on this
Thank you. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Okay, was notice of the hearing posted on the subject property?
Yes, sir.
Okay. All right. If y'all are good with it, we'll have them go through maps and photographs, please.
Good morning, Board. Caleb McCarty, AICP Certified Planner for Escambia County. First, we have our location map showing the property along Bellevue there. This is our 500-foot radius zoning map. The property is currently LDR. The future land use of the property is mixed-use suburban. And the property is currently vacant, and this shows the surrounding uses between the fairgrounds and the single-family residential dwellings in the area. This shows wetlands in the northwest corner of the property. And this shows some surrounding subdivisions that have been discussed. Another aerial of the property here. This is our notice of public hearing sign that we posted along Bellevue Avenue. This is looking north onto the site, grass area, and this is looking east along Bellevue Avenue. This is looking west along Bellevue Avenue there. And this is looking south across Bellevue. We did also post some public hearing signs at the end of Buckland. That's the subdivision to the north. So this is looking south towards the site, and it's actually wooded up that way. This is looking west from the site. This is a stormwater pond on the north along Buckland, and this is looking north along Buckland as well. That concludes our maps and photography for this case.
All right, thank you. And then at this time, I'll have the applicant or their representative come forward. All right, and you are an attorney, so we don't have to swear you in, but if you do bring any witnesses or anything forward, we'll do that at that time. If you'll just state your name and address for the record again for us.
Yeah, Bill Mitchum, 501 Comendencia Street, Pensacola, Florida, 32502.
All right, and did you receive a copy of the hearing package with findings of fact for today?
I did.
Okay, and do you understand that you have the burden of providing by substantial, competent evidence that the proposed PUD is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code?
I do.
All right, and so we'll let you go ahead and make the presentation you have this time.
Yeah, so we agree with the findings. I'll say that first. The PUD meets all the requirements of the LDC. Its design demonstrates creative concepts of land use, planning with the size of lots, placement of common area, and use of buffers. The setbacks, buffers, and smaller lots are an efficient use of the land and enhance and preserve the natural amenities and characteristics of the land. And the PUD includes a network of sidewalks promoting pedestrian mobility, and the proposed density is compatible with the predominantly medium-density single-family development of the surrounding areas. All of that was borne out in the staff analysis and comments. In addition, PUDs are to provide greater public benefits than would otherwise be available, and those include the stormwater infrastructure improvements that we discussed earlier with the development agreement, common space and park area available in walking distance to the lot owners, the unimpacted wetland area that is buffered as shown in the PUD, and the 20-foot buffer that Mr. Wilson discussed, that's a drainage and a buffer between the Rosewood Estates subdivision and any of the lots in Skyline subdivision. So all of these were addressed in the staff comments and analysis, and all of them support a PUD. As it relates to the rezoning, the property meets all the requirements for rezoning from low-density residential to medium-density residential. It's in a future land use category, mixed-use suburban, where the comprehensive plan seeks to promote residential development by allowing rezonings up to a higher density. The MDR district is appropriate to provide transitions between low-density residential and higher density uses. So, as you'll note from the the map, the property is bordered by high densities. Has the fair on the right, and then medium density on the west, and then medium density south. Medium density residential is compatible with the surrounding uses, which is generally residential. It's not spot zoning, as it's bordered by medium density residential, again on the west and on the south. And the rezoning would not create or contribute to urban sprawl, and the use of the property as residential development is consistent with surrounding properties and uses. And again, all of this is set forth in the staff findings and analysis.
All right, thank you. Are there any questions for the applicant at this time? All right, I don't see any, so we'll just sit down. If we need to, we'll get you back up here.
Thank you.
All right, staff, I'll let you go ahead and take us through your presentation at this time.
All right, we're going to provide you with a staff analysis for the plan unit development as it's required by the Land Development Code. Concerning criterion A, a general description of the proposed development. It's located in Escambia County, currently addressed at 500 Bellevue Avenue. The proposed PUD is situated on approximately 19.58 acre parcel located within the low-density residential zoning district, shown as mixed-use suburban future land use. And the applicant is currently requesting rezoning of the property to the medium-density residential district. The applicant in the PUD is requesting variations. Number one, a reduction of the required minimum width at the front building line from 50 feet, as required by MDR, to 30 feet for all lots. Number two is a request for the reduction of the required minimum rear setback from 20 feet, as required by MDR, to 15 feet for all lots, and a required 5-foot minimum side setback for the individual lots. Concerning criterion B, the limits on PUD, as the chairman read, concerning number one, the land uses, we found that the proposed single-family residential use is allowed by the applicable zoning district and the future land use category. Number two of criterion A is the density. The proposed number of dwelling units does not exceed the residential density allowed by the zoning district and the proposed applicable future land use category. The applicant is proposed 6.8 dwelling units an acre for a total of 134 dwelling units. In comparison, the MDR zoning district allows a maximum density of 10 dwelling units per acre, and for a 19.58 acre development, this would allow 195.8 total dwelling units. Number three, other processes. We found that the preliminary development plan of the PUD has been forwarded to the planning board for its consideration after review and written consent by the members of the DRC, the Development Review Committee. Prior to PUD plan review and final determination by the Board of County Commissioners, the plan must address any remaining conditions of the Land Development Code compliance not modified by the proposed variances of the PUD, and must respond to any conditions of the Planning Board's recommendation to the BCC. The essential commitments of the development plan and the expectations of the county will be established upon Board of County Commissioner approval of the PUD, which includes the preliminary plat and associated documenting plans. The implementing subdivision infrastructure construction plans and the final plat must be in substantial conformance with the approved PUD plans as determined through the established review and approval processes of the Land Development Code. And concerning number 4 of B, standards, the proposed development will comply with all applicable level of service standards. Criteria C, compliance review. The planning official has forwarded the proposed PUD and analysis of its compliance with the requirements of the Land Development Code to the Planning Board for its required consideration and recommendations, meeting that criteria. For D, our criteria for PUD approval. Number 1, as the chairman read, concerning creative planning. We found that due to the stormwater needs within the surrounding community, the applicant will expand the Rosewood Estates retention pond, allowing for additional stormwater storage capacity for Rosewood Estates and this proposed Skyline subdivision PUD. The pond expansion and improvements must be designed in compliance with applicable local and state regulations. Single-family dwellings appear to be a sustainable land use for the site. No mix of dwelling unit types is documented in the submitted plans. No non-residential uses other than accessories to the dwelling units are proposed within the subdivision. Our recommendation is that the PUD document the characteristics of the dwelling units, which the PUD can't commit, such as floor area, storage, provisions of garage or other parking outside of right-of-way, and any diversity of housing and material. Number 2, natural amenities. We found that smaller lots are among the methods used to maintain valuable density while preserving natural amenities and characteristics of the land. A small area of wetlands exist in the northwest corner of the development area and are buffered as required by the Land Development Code, and no impact is shown. As referenced in the applicant's submitted narrative, the enhancements include stormwater improvements and modifications. Therefore, this criterion has been met. Staff recommends and agrees that this criterion has been met per the proposed project for the protection of the natural amenities as submitted and will be reviewed further in the next development review stage. Number 3, desirable environment. We found that the proposed development will be completed in one construction phase. We note that greater public benefits include the stormwater infrastructure improvements for the proposed development and the adjacent Rosewood Estates subdivision. Number 2, centrally located common open space and park area available within walking distance of all proposed lots via the constructed sidewalks. 3, unimpacted wetlands that is buffered from the proposed residential uses. And 4, buffering provided to the adjacent Rosewood Estates subdivision. Staff recommendations, the proposed The proposed development provides public benefits greater than from a typical subdivision within the MDR zoning district. Preliminary plat and construction plans will be reviewed to ensure that those benefits proposed and approved by the county will be integrated into the subdivision's design as required. Number 4, mobility. Safe and effective pedestrian vehicular mobility within the subdivision is promoted through compact upland development, and a network of sidewalks on at least one side of every street frontage is proposed for the development. Number 5, efficient land uses. Smaller lots and the limitation of improvements support an efficient use of land that results in smaller networks of streets and utilities. Easements will supplement proposed less than standard width, right-of-way widths to accommodate utilities. 6, compatibility. We found that the proposed density of single-family detached dwellings is compatible with the predominantly medium-density single-family development and commercial development of their surrounding areas, and the constructed improvements of the residential subdivision will provide the stable conditions and characters to maintain that compatibility long-term. Other considerations, finally, in review and analysis of the proposed development, the planning board may include conditions relative to the 6 LDC criteria for the PUD approval to ensure the intent of the process is achieved. Note that the PUD approval is contingent on the rezoning of the property to MDR, and that the applicant is also relying on the acceptance of the voluntary development agreement with the county for the proposed infrastructure improvements and commitments as shown. That concludes staff's analysis for this plan unit development.
All right, thank you. Board, are there any questions for staff at this time? All right, don't see any. Okay, for those members of the public who wish to speak on the matter, please note that the planning board bases our decision on the approval conditions and exceptions described in section 2-6.8 of the Escambia County Land Development Code. During our deliberations, the board will not consider general statements of support or opposition. Accordingly, please limit your testimony to the approval conditions and exceptions described in section 2-6.8. Please also note that only those individuals who are present and give testimony on the record at this hearing before the planning board will be allowed to speak at the subsequent hearing before the Board of County Commissioners. Ms. Blackman, I see.
Sorry.
You got something? Do you want to jump in before we get to public comment?
Just wanted to speak briefly. I have other appointments this morning, so
Okay.
My statement still stands in your record, of course, but to try to just offer clarification, and I may be repeating myself, but sometimes I have to. So I remember, so I'm just trying to help everyone understand. This site, in our discussions, is unique in their approach because they are going to develop this site to the current standards required by the county for both subdivisions as if they're developing from scratch. So the pond that exists today is terribly undersized. We have no additional property to expand the pond. My hope in generating this design, or previous to them coming into office, was to try to find property that I could add another pond in this area. So this is bringing us, the county, the expansion to the pond that we already needed. Also, any road topping, flooding, we'll try to minimize that, if not eliminate it completely, because I haven't seen the model. I don't know yet what it's going to do because they haven't invested in that part of it yet. But at a minimum, we will need to see that there's no road flooding in Rosewood, no homes flooding in Rosewood. These homes won't flood, and that there is a good outfall for this to the Hogan's Pit Pond. So that's and if I can answer any questions, I'd be happy to at this point, but I'll come back down if you need me later, but I need to go to another appointment this morning.
All right, does anyone from the board have any questions?
I'm just curious, Ms. Button, briefly, how does the voluntary compliance between the developer, engineer of record, and yourself, how does that work?
Well, in the pre-application discussions with this developer and their engineer, We explain that, there's just untold flooding in this area. We haven't been able to manage it. The previous applicants that have come in have indicated they would expand the pond into their pond and, improve the outfall, which, seemed the minimum standard that they would have to do. But they're going above and beyond that. How this comes about is through the conversation that when it doesn't meet, when today's standard is not enough, or the minimum standard is not enough, because we already have flooding. So we needed more than the minimum standard, and they came with this suggestion or this request that we do that, and I asked for a little more than that when we talk about Bellevue flooding and that sort of thing. I asked if they, or I indicated I need the crossing, I need the outfall to be clean. I need to be sure that Zachary's outfall is working properly. So we need to upgrade all of that. And they agreed to that. It's a collaborative effort. It's very rare, but I have had some luck with that in the past. As you've heard me say, no engineer was taught to design to minimum standard. I mean, it's thrown back at the county many times. It's not in the code, it's not in the code. Well, it is in the code that I have some prerogative when I know that there's already existing problems to require more than the minimum standard. And engineers don't want to hear the word house flood. They don't want to hear the words liability, and they understand that while I'm not personally liable, they will be. And they're going to give me the assurance that to the extent of the 100-year storm event that we require, it will not flood those homes.
Any further questions? All right, thank you. All right, our first speaker that we've got is David Gibson. If you'll please come forward and state your name and address for the record, and then be sworn in. And it's a quasi-judicial hearing, so it's a little different than last time you spoke, so we got to get you sworn in because this is on record.
No problem, thank you. Dave Gibson, 6008 Yellow Rose Drive, Pensacola, Florida.
Raise your hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
And Mr. Gibson, before we get your time started, I will just remind everyone as well, with these cases that we have here, we're basing our decision on the 6 criteria that we went through earlier, which I know was a lot. So staff, if could have that handy. So if you'd like to reference that, will be, if you're making your arguments for or against the case today, I would base them in one of these 6 categories, why you agree or disagree with what's being proposed. So just throwing that out there. Okay, Mr. Gibson,
And
go
if
ahead.
I get sway into not addressing them, because I don't have a copy of that, and there's a lot of legalese in there too.
That's
so,
okay.
Okay, just real quick bullet points. This was compounded, this issue we had when the state did their work 20 years ago, maybe 25 years ago, up on Blue Angel, and diverted water from Blue Angel onto Bellevue. It was further compounded when they came in on the south side of Bellevue and filled the ditches in and diverted all the water to the north side. It was further compounded before that when Zachary Estates was finished and built out, and on the west side of the subdivision I'm in, the water was diverted into Rosewood there. And so, and what we hear from the county is, well, we don't own that right of way down through there. There's nothing we can do. So it's going to be a continued ongoing issue for us. There's a clay. You go down about 3 feet into the soil there. There's about a 12 to 14 inch clay layer, which was mined. To the east of us, there's a clay pit there, former clay pit, and the water does not perk in the lawns, and so there's issues that is there that is natural that needs to be considered. The ponds which next to me was when I moved in there, would have water continually standing in there because the water didn't perk. The county came in and broke through the clay berm that was there, or layer that was there, and it perks. It still takes anywhere from 3 to 4 days for it to perk and go out, which means the water's still standing in the neighborhoods. Now, the street will clear anywhere from 8 to 10 hours, but there's constant runoff from the subdivision that continues to go into that pond. So the ponds are going to have to be deep. The water, once it fills the dishes, once the pond is full, the water starts going, let me back up. Once the ditches are full, the berm is not high enough around the ponds, and the water starts backfilling from the ditch into our pond. So the sides of the ponds have got to be higher. And so it's an issue that's going to be ongoing unless we can get some more input into it. And so with that, I yield back. Unless you got a question for me.
All right.
Thank you.
Any questions for the speaker? All right, seeing none, thank you. Mary Knopf, if you'll please come forward and state your name and address for the record and be sworn in.
My name is Mary Konopka. My address is 6248 Muldoon Road.
Raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. Somebody said that it was MDR to the south of that property. I don't see that. To the south of that property, we're all on pretty expanded acreage. The only MDR I see is to the east of that property. Every place else, I see houses built to an LDR standard, so I'm confused about that. Again, developers have worked with engineering to meet minimum standards or just above. I have a list of failed areas, and it's my tax dollar. It's your tax dollar. Every time they build and they leave and there's a problem, it's our tax dollar. So when you're talking standards, instead of talking the standards that archaic standards that this county has, let's talk about 2024 Florida DOT standards, not 1979. The other thing I just found out here, talking to the person that was here for the church, is that they're trying to sell that property because they found another property. And they want to sell it and make enough money to pay off the property that they bought. That's a little greedy to me. The county records say they got that property for $10. And 4 units per acre, keeping it LDR. You know, what's the matter with that? And Joy Blackman would have the land that she needed to develop ponds. I brought up here several times in the past. Let's make it a park. Florida State. We don't have a park in our neighborhood. Florida State will help us buy a park, and then the county will have land to do whatever they need. And somebody up here said, we don't want a park. Maybe you guys don't want a park. But we live there. You guys don't live there. We live there. We'd love a park. And that would give Ms. Blackman plenty of room to design so that we don't flood. It's not just Rosewood and Zachary Estate that's flooding, that insufficient pond is up there for. It's all the way down Muldoon Road. And again, before I get emotional, it's ruining my business, my livelihood.
Thank you. And I'll just, they did bring the map up here from Ms. Konopka to show you the different zoning areas in the, around where you're talking about. So it may not be that the structure that's on the piece of property is at capacity for what the zoning is on your land, but it certainly has the opportunity to if you know, you or someone else came in and wanted to do something on that piece of property. So you've got MDR, HDMU around there. So I just wanted to show you that.
Why was the land that we're discussing initially zoned as LDR?
I can't recall. I know we've probably asked this before. It's probably a previous zoning category that was there when they transferred everything over. And
Yeah, we can put that up for you. Sorry about that. We can put that up for you, but more than likely, we have to put up the map. It probably was R1 or R2, which was a single-family dwelling district. And when we had the conversion, it got properly converted over to low-density residential, which will be similar to R1 and R2. When it got properly, we had some conversion back then.
I remember that.
So it was B2A, which was just like R1 or R2. So it was properly converted, low-density residential.
So
all
let's
right,
keep it
thank
that
you.
way.
Thank you. All right, next up we have Tina Lynn. If you'll please come forward, state your name and address for the record, and be sworn in.
My name's Tina Lynn. My address is 6813 Chicago Avenue.
Raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. Instead of just reiterating everything that I have stated prior to it regarding the flooding issues and the concerns of the people, the residents in that area, I don't live in that area, but I know them. I go through that area. I see their heartache because I felt it myself to an extreme limit. I've lost faith in a lot of the county themselves because I have talked to many people over the years about who's going to fix this. Nobody wants to ever take responsibility for things that have been done in the past, inspectors that didn't do their jobs. And it's the homeowner that suffers, that has to put out thousands of dollars to do repairs or to find a solution. And that's what gets at my heart because I have battled that myself for years. And seeing what's going on with their retaining ponds in that and what it does to their property and their business, that's not right. And it's our county tax dollars. We pay those tax dollars from our pockets, and it goes to benefit everybody in the county. And they need resolution just like everybody else. And putting more people in a smaller area is just going to add more congestion. It's going to add more possible flooding issues. And where is the guarantee to these existing homeowners that they won't have that problem after they build this new section in there? And there is nobody can guarantee. So where is their option after that? What do they do? That's part of the heartburn. That's my feeling on this area, but I appreciate it. Thank you.
Thank you. Mr. Curb, if you'll please come forward and state your name and address for the record and be sworn in.
Chris Curb, 5999 Somerset Drive. Let's come forward.
Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Absolutely. All right. Those two documents that I provided up in the development agreement, I would like to ask that those be submitted in the record for this zoning case. So I'd like to continue on that.
All right, so Mr. Kerr was asking that the information provided earlier be entered into the record of evidence for this case. Board, if that is the wish of this board to do so, I'll accept the motion. If not, we will continue on, let Mr. Kerr take his time and speak.
And just for clarification, all this is the Florida statute, and that's really all you're submitting to evidence is the existing Florida statute, correct?
With my notations. Which is also documented state document, so.
I'll make a motion to approve it and submit this as part of his testimony so that he can carry this into the Board of County Commission.
Okay. Got a motion, second. Any discussion? All those in favor, please signify by saying aye, or raise your right hand. All those opposed? Okay, motion carries. Thank you, Mr. Kerr.
First of all, I want to express that I'm not opposed to this property being developed. Actually, I think growth is good as long as it's done the right way. And it looks like there's been a real big challenge on this property to get it developed because of the stormwater issues. The plan that was put forward that y'all approved, the development agreement, that's a good plan. And there's a good sized pond there. And Tom did a pretty good job putting a plan together with the county engineer coordination. However, the fact of the matter is the Hogan Pit Pond is not expanded right now. It doesn't have the capacity to accommodate the water going to it. And we're still using 1979 rainfall data. In this memo that Joy wrote, it says key benefits, modernized stormwater system. Well, it ain't modernized if you're using 1979 rainfall data that's 2 to 3 inches less than what it should be. It's also not modernized if you're doing a 100-year, 24-hour storm with a 6-inch freeboard. Because what DOT has published is modernized. In your approval conditions under E, it says appropriate with change or changing conditions. It says if the land uses or development conditions within the areas surrounding the property or the rezoning have changed, the changes are to such a degree and character that it is in the public's interest to allow the new uses, density or intensity in the area through the rezoning. Well, I submit to you that it is not in the public's best interest. Thank you.
Thank you, Mr. Kerr. All right, next we've got Joshua Zeller. If you please come forward, state your name and address for the record and be sworn in.
Joshua Zeller, 6506 Lake Charlene Drive, Pensacola, Florida.
Do you solemnly swear that the testimony you are about to give will be the truth, and nothing but the truth?
It is, yes. So, like I mentioned before, I think I agree that this area has a flooding issue. I agree that it needs to be fixed, and I also think that since the developer, like I think what Ms. Blackman mentioned, the developer has offered to do a lot of this work, right? And the only way for them to be able to justify or be able to finance a lot of this work is to be able to change the zoning, because if there is only a low density zoning, the numbers will just never not work, right? And as far as also the tax burden for maintaining a lot of this, the numbers might not work, right? So I know as far as the developing part, if it is the county's interest to be able to fix that and put that on the developer, like they had mentioned, the rezoning is a key to that being feasible, because without that, they will not. I mean, I don't want to speak for them, but it's very unlikely for them to want to do all this extra work if they are not able to then develop it to the PUD that they have presented. And like I said, I think the other thing is that right now this area is we have kind of struggled a little bit with as far as housing, and I know prices are coming down. And so if we can create more volume as far as housing being available, it will help also with the prices. It will help with a lot of things that the county the residents that are living here are struggling with. So I think this is not only helping the developer fix the issue, it is also helping the county provide more homes for the population growth that is happening right now. Thank you.
Thank you. And then the last speaker I had was Ferdinand Zeller. If you'll please come forward and state your name and address for the record and be sworn in.
Ferdinand Zeller, 7174 Woodside Road, Pensacola, 32526.
Raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Okay, I'm already related with Joshua, and we were planning many years ago to build a church there, and that's the reason we bought this land. But then prices went to the roof, and it was not possible for us to go through with this project. And then we found another church that was already built, and then it was within our budget. And I understand all these problems that they have with the flooding, but as my son said, this developer is going to address this. And some people, they say it's further down and Muldoon, there's a flooding too, but in a way it can't be the responsibility of the developer to take care of that as well, because they take everything around this area and they try to do the best. In my opinion, they go out of their way to make it better. If we don't do anything, as my son said, nothing will change. The flooding will continue. And it seems the county is not able or not willing to invest all this money. And I understand what they say about this increasing of houses and increasing of people coming in. But we came into the city 22 years ago, and we were living up there on 9 Mile Road, and this was just a country road. And now you go there and there's a highway. And in a way, that's part of growing. I mean, I understand that there are neighbors there and that they don't like that so many houses come in, but it's a city of growing, and that's part of the growing pain. And that's my opinion.
Thank you very much. All right, I had no further speakers from the public, but we do have the engineer of record for this, Tom Hammond. If you'll please come forward. State your name and address, be sworn in, and we'll get you going.
Tom Hammond, Hammond Engineering, 3802 North S Street.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Do we need to be sworn in, expert witness in this?
Yes, sir. If you'd like to, we'd have to do it separately.
Yes.
Let's do it. Yes.
Make a motion to accept as an expert.
Second.
Okay, we got a motion and a second. Any discussion? All those in favor, please signify by raising your right hand. All opposed? All right.
Okay, thank you. In response to the first gentleman that spoke, he talked about the soils. There's loamy soils there. They're very poorly drained soils. So he's correct on the pond's not perking. So we have a sand chimney in our design located on the east side. It's a foot lower than the west side of the pond. So the water will always flow away from Rosewood. And if it does stand up until it's gone in 36 hours, it'll be sitting down on the southeast corner. That's how we address the soils and address perking problems that he brought up. Again, we heard, they lost, the public in this area lost faith in the county, and we have existing conditions out there today that if we don't do anything, they got a flooding problem there today. This is a developer partnering with the county, asking for a variance, and in return, improving the problem, putting infrastructure in to address flooding issues that are there, whether we do this development or not. And thirdly, we are using old data. I made this argument in front of Santa Rosa County Board, made this argument in front of our county board. The problem is that our existing data cannot be proven to be insufficient for development today, because no one can step up here and point out a single subdivision I did or any of these other engineers did since 2014 that flooded or failed using the old data. And when I presented that to the board on both counties, they chose not to take up the new data and require it, because it's only going to affect new development. You're still going to have Rosewoods and all this old development, Bristol Park, Cordova Park, all the things listed in the 2014 report that the county put out 2 years later, and none of them were new developments that needed to be addressed. The data we're using is adequate until somebody can prove it isn't. And until that such time, I don't think the development community ought to be using NOAA Atlas 14 when it can't be proven that what we use now fails. Thank you.
Any questions for Mr. Hammond from the board?
Mr. Hammond, I'd kind of like, I mean, I work in construction. I know people struggle reading drawings. I think we assume people understand how to look at this plot plan. I would call this a plot plan, not really a grade plan, but can you walk us through this image that you've kind of designed here and show some grade, and then explain the actual detention pond sizes so we can walk them through that? Is that possible to do?
Absolutely.
Okay.
Okay, so you can see we're on the on the south side, which is the right side of my plan. Yeah, north. So you see the little rectangle down there on the Rosewood side. If I had a light, I'd show you. Okay, so all the way over on the west side, off our property is that little square is the existing pond. So we're regrading that pond. And we're making the bottom of that pond 1 foot higher than the bottom on the east side. So that water never stands there. It flows, comes under the road, and will go out the same chimney on the east side. I would say, and I don't have these numbers in my head, but we're probably 2.5, 3 times the size of what Rosewood Pond would have been. That's just a portion for our development. And it's probably 4 times, 5 times bigger than the Rosewood Pond, the whole thing altogether. So you can see that under the old, if we use the old code, which like I said, it went in between 94 and 98, and I think Land Development Code was adopted in 87. Yep. So, you know, it was a 25-year storm then. I haven't looked at them calculations, tried to find them. I don't know that the county would even have that anymore. But that's why I grabbed it and said, let's do this like it's never been developed before, all these parcels, and even a part of Zachary that flows on to Rosewood. And that's how we had to set up the model. Does that help a little bit?
Yes, for me, I mean, I know how to read this, but I think just to let the public understand, this entire south section of this entire humongous lot is storm retention now.
That's correct.
Yeah.
The entire frontage.
With a 20-foot drainage on the west side from the north to the south, is that, and that's
Yes, sir.
pulling from the water from up north, that's also been causing issues, is correct?
Yes, sir.
The elevation change over what it's currently today, when this subdivision is built, how much will the grade change up, down?
I think I have the top of the pond designed at the same height as the top of the Rosewood Pond.
Okay.
Thank you, Tom.
Any further questions for anybody from the applicant or for staff at this time?
And if I may,
Okay.
Mr. Woodson, And in the plan unit process that we are discussing at this time, is we are very grateful that we can have these type of discussions, so you get into a little bit of the design criteria that they are enhancing. That's the purpose of the PUD, to enhance, to make it better, so you won't get the same status quo. And that was the purpose of the development agreement, to make it better, to address the specific problems that are occurring, and they are volunteering. The PUD process is not a mandatory process. Again, this is a volunteer process. What they're going to be adding, yes, they're going to be adding some creativity to make it better, and with some enhancement that they are requesting. So this is the type of development, type of project that the county is saying, yes, this is what we want to make it better, to partner with through the PUD process. Larger ponds, taking an existing pond and making some substantial improvement on that. So that's why the county is supporting the creative concepts with the volunteer effort. Not that we are dismissing the concerns of the neighborhood. No, because the county engineer was adamant about that. We know there are problems. I know there are problems. But sometimes maintaining the status quo is more detrimental than getting the opportunity to proceed for better development, and as well as make the conditions better. Sometimes maintaining the status quo sometimes may be more detrimental.
I do have a question, and I don't know if this can be something get answered at this time or not from the applicant, but at what point in the process is the retention pond done? And I guess what I'm asking is that done first before development goes on, or is that done at the very end, or all at the same time?
That's during the construction process, with the PUD process. All of these things got to be in place before there's final plat approval.
Right, I get that, but I'm saying when we start to dig dirt, if they get everything that they need from the county to continue on, at what process does the stormwater issue begin? At the end of houses being built or before houses being built? Or is that something that can even be answered at this point in time?
Go ahead, Caleb.
Yeah, I can answer.
Okay.
Ask of the applicant, Rodney Sutton, 120 East Main Street, Pensacola, Florida.
Raise your right hand. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do. And so when we get the development order and we've met all of the criteria, we start construction, we finish complete construction of all of the lots and the infrastructure, the ponds, the roads, everything. We have to get a final plat, and that's when home construction can start. So not before. The ponds will be completed and accepted by the county before we start any home construction. But also, if it's okay, we'd like to address a question asked earlier about how all this came about. And from the applicant's perspective, Joy got up and explained, and I was sitting in that room along with some others when that happened in the pre-application process. So from our perspective, we saw this potential development bounce back and forth between this board and the county commission a couple times, and every time address the stormwater before we're willing to proceed. So we knew when we tackled this that was the issue that had to be addressed. And so we came to the pre-application meetings, and I just want to applaud staff because I feel that staff has represented very well the folks that are sitting here and are rightfully so upset. Because we were on the other end of those, if you'll call them negotiations, we were there voluntarily to try to figure out what would work. And the solution that we came up with, and we spent a lot of money on geotechnical, spent a lot of money on, topo, and spent a lot of money on engineering to get it done right. And we feel like that staff pushed a solution that took what is currently a problem and came up with a solution that fixes a good portion of it upstream. We can't fix everything downstream, but if we can eliminate a problem up here, then the Hogan Pond can feel some relief from that downstream. And so we can do that portion of it. And one other thing would like to, from a layman perspective, I'm not an expert witness, But, you know, I think that a very good point was brought up about the soils in this area. When we did the geotechnical reports, there are, we'll call clay layers that sort of block the water from perking. And the sand chimney, you know, that was mentioned, it breaks through that, and it creates a chimney, if you will, through that layer that allows the water that would have perched above clay to get through the sand into the aquifer down below. And so that's an important component. Not only are these ponds 10 foot deep, you know, and massive expansion of what exists for these two subdivisions, but that is another feature that's extremely important. The connection of the potential, you know, swale and buffer on the west side of the property, connecting a wetland down to our pond system, in addition to all the inlets and, you know, infrastructure that will get water to the ponds, is also a big improvement. So we did this voluntarily. Staff has pushed us very hard to make sure we meet the standards, and we've been willing to do it based on this PUD approval. So I hope that also answers the question about sort of how all this came about.
Appreciate it. Thank you. All right, board. We've heard from staff, applicant, and the public at this time. So again, if there's no questions for anyone that's spoken from up here, then we'll continue forward, and I would entertain any discussion and or motion that would like to be brought forward. So because this is quasi judicial, I'm going to leave it where we've let people speak and put their testimony on the record at that. And I apologize, but because of this setting, I'm going to continue moving forward. So board,
Mr. Chair, based on staff findings and compelling information that the developer has the Rosewood folks in mind and has extensively invested in improvements to better the drainage, I make a motion to approve.
okay, can I ask you to make your motion contingent upon the next rezoning case?
Yes, contingent upon the next rezoning case.
Okay. All right. So we've got a motion for approval of the PUD contingent upon the rezoning case that follows this.
Second.
There's a second. Is there any discussion on the motion? Seeing none, all those in favor, please signify by raising your right hand. All those opposed? All right, motion carries 6-1. All right, next we have got rezoning application for consideration, case number Z-2025-04, which requests rezoning of Bellevue Road from LDR low density residential dwelling units, 4 dwelling units per acre, to MDR medium density residential district, 10 dwelling units per acre, as requested by William Mitchum and Rodney Sutton, agents for House of Prayer for All Nations, Inc., the owner. Members of the board, have there been any ex parte communications between you and the applicant of the applicant's agents, attorneys, or witnesses, with fellow planning board members or anyone from the general public prior to this hearing? Have you visited the subject property? And please also disclose if you are a relative or business associate of the applicant or the applicant's agent.
No to all.
No to all. No to all.
No to all, except a member of the constituency reached out to me about the agenda today.
Okay, no to all.
No to all.
No ex parte, but I did visit the site today.
No to all.
Again, no to all, know the site, and SNS are clients, but there's no prejudice.
Staff was notice of the hearing sent to all interested parties.
Yes, sir.
Was notice of the hearing posted on the subject property.
Yes, sir.
All right, and if we're still good, we'll allow them to go on with the maps and photographs for this case.
All right, thank you, board. First, these are the same as the plan unit development that we saw a minute ago. This is our location map. 500-foot radius zoning map showing the property low density residential. The future land use is mixed-use suburban. The site is currently vacant. This shows the surrounding wetlands, and this shows the subdivisions in the area. Also, we attached an aerial map. This is our notice of public hearing as we posted on Bellevue. This is looking north onto the site again, looking east along Bellevue, looking west along Bellevue, and across Bellevue Avenue. We also posted our signs again at Buckland, and this is our photographs looking south from Buckland, looking west from the site, looking east towards the stormwater along Buckland, and looking north. That concludes our maps and photographies for this case, rezoning case.
All right, thank you. Now I have the applicant representative, please come forward. Mr. Mitchum, you've already, we'll just have you again state your name and address for the record for this case.
Sure,
And
Bill
then-
Mitchum, 501 Cominancia Street, Pensacola, Florida, 32502.
All right, and did you also receive a copy of the rezoning hearing package with findings of fact for this case?
I did.
And understand still that you have the burden of providing by substantial competent evidence that the proposed rezoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of the comprehensive plan, and is not in conflict with any portion of the county's land development code.
I do.
All right, please go ahead.
I think I actually mentioned this in the last case number, but I'll just say again quickly that this rezoning meets all the requirements from low density residential to medium density residential. It's in a future land use category, which promotes residential development by allowing rezonings to a higher density. The MDR district is appropriate to provide transitions between areas zoned or used for low density residential and areas zoned or used for high density residential or high density mixed use. The property to the west of our subject property is zoned MDR. The property to the north is LDR, and the property to the east is heavy commercial and light industrial. So it fits in that transition. MDR is compatible with the surrounding uses, which are generally residential, whether low density residential or medium density. It's not spot zoning, as the property to the south and the west are MDR, as we saw on the map a little bit ago, and the rezoning would not create or contribute to urban sprawl, and the use of the property as a residential development is consistent with the surrounding properties and uses.
All right, are there any questions for the applicant on the board? All right, thank you, Mr. Mitchum. Staff will have you go through your presentation at this time.
Excellent. Again, this rezoning's from LDR, 4 dwelling units per acre, to MDR, medium density residential, 10 dwelling units per acre. Consistent with the development agreement, remember that that item would be capped at 134 acres rather than the 190 something that's otherwise allowed. Dwelling units, excuse me. We found that it did meet all criteria for the rezoning request, in particular criterion A. We found that the request to MDR is consistent with the future land use category of mixed-use suburban. That mixed-use suburban does allow for residential development in accordance with various comprehensive plan policies. The maximum densities and intensities are encouraged in underutilized properties in this future land use category of mixed-use suburban, and it is allowed to promote the efficient use of the existing roads, utilities, and infrastructure. Concerning criterion B, consistent with the land development code, we found that the proposed amendment to rezone to the MDR dwelling density residential, medium density residential zoning district is consistent with the intent of the land development code. The primary intent of the LDR zoning district is predominantly detached single-family dwellings with a maximum allowed density of 4 dwelling units per acre, and to preserve the character of the existing established communities within the LDR suburban area. The MDR zoning district is appropriate to provide the transition between areas zoned or used for low-density residential and areas zoned and used for high-density residential and high-density mixed uses. As with the LDR zoning district, MDR allows for single-family uses, but a higher density of 10 dwelling units per acre. The property to the west is a platted subdivision with the same zoning as the proposed MDR. Additionally, the rezoning to MDR is an appropriate transition between the MDR property to the west, the LDR property to the north, and the ACLI heavy commercial light industrial property to the east. The property will be limited to single-family residential development due to the previous zoning designation of V-2, as came up earlier. Also, our traffic and transportation operations staff provided us with a memo stating that there's no traffic capacity concerns related to Bellevue and the vicinity of the projects. There are existing speed tables on Bellevue Avenue. This is solely based on the rezoning application submittal, so there may be additional comments related to the development review process. Criterion C, compatibility with surrounding uses. We found that the proposed amendment is compatible with the surrounding properties in the area. The uses are similar to the allowed uses on the requested MDR zoning district, which is single-family dwellings. Within a 500-foot radius area, all properties are with the LDR, MDR, and ACLI zoning districts consisting of single-family dwellings or commercial uses on individual lots. The abutting MDR zoning to the west is a single-family dwelling subdivision of approximately 18 total acres. The resulting density of the west is calculated to be 2.5 dwelling units an acre. The LDR zone property to the north is approximately 10 acres and also a single-family subdivision with a density calculated at 3.2 dwelling units per acre. And hence we included the subdivision map in our findings. Criterion D, appropriate if spot zoning. We found that this would not be considered spot zoning. And criterion E, appropriate with changed or changed conditions. We found that the land uses or development conditions within the area have not changed. The development within the area has remained low to medium density residential. And with the request for MDR, the potential uses, densities, and densities allowed by that district would be compatible with the existing surrounding development patterns. The proposed amendment will not create or contribute to urban sprawl. A further note, the rezoning proposal is included with the planned unit development of the property, providing flexibility to the land development code requirements for encouraging benefits to the developer and the public. The applicant also submitted the voluntary development agreement to the county, seeking to provide predictability for the community in relation to the property. That concludes our staff's finding for this rezoning.
All right, any questions for staff on their presentation?
Mr. Chair,
Yes.
from the school district side, and Horace will know this, we get congested down there on Bellevue Avenue on that end. So it may have to be some modifications by the county to make sure that traffic can still go through, because you got two schools that are entering, but they're off Bellevue Avenue. No light on Blue Angel.
Right.
Yeah.
During the preliminary plat phase, we will definitely, that proposal gotta go before the school board officials to review for concurrency, yes, sir. So that would definitely have to be part of the discussion, which I know the engineer record is definitely aware of all of those things as well.
And for this board to know, that is the most active complaint area I have in District 1.
Thank you, Mr. Adams. Any further questions at this time? All right, we'll get started with our speakers. And I think all of you have already been sworn in, but we'll just have you state your name and address again. So Mr. David Gibson, if you'll please come forward and state your name and address. And again, we've got you sworn in already.
Thank you. David Gibson, 6008 Yellow Rose Drive, Pensacola, Florida. If I get away from what this one's about, just correct me and I'll move on. Just correction of some things that were said. The water issue was stated it was the east side of Rosewood. It's not as far as backyards flooding and houses flooding. It's on the west side coming off of Zachary Estates. The engineer stated that he was going to raise the berm to level with what's coming off or what's there now with the Rosewood catchment pond. One of the big problems with the water issue is the ditch filling up and backfilling into the pond there. And so the berm's going to have to be higher than the current pond because we'll have the same issue. The pond will fill up from the ditch. It's not catching the water from Rosewood. And I don't know if it's appropriate. Could I yield my time to Chris, the rest of my time?
Oh, we can't do that unfortunately, but I
Okay.
appreciate
Well,
it.
that's all I have.
Okay.
And
Thank you
I've
very
got to
much.
leave. I've got another appointment I'm already
Okay.
late for.
Thank
you. Thank you.
Thank you for coming.
Thank you for considering.
Mary Kanopka, well, you come down to state your name and address. You've been sworn in, so we'll get you going.
Mary Kanopka, 6248 Muldoon Road in Pensacola. Traffic. I'm so glad somebody brought that up. The traffic counter right now is over 100 feet from Blue Angel. If you look at your Florida traffic map, you can look online. Jim Hagren at Traffic can help you figure out all the little icons. But it's not accurate. It's most of the traffic on Bellevue is Bellevue and Muldoon. Because, as you mentioned, Blue Angel and Bellevue doesn't have a light. So nobody goes out Bellevue to Blue Angel to turn left, especially in the morning going to work or at night coming home from work. The other thing I want to say is, yes, Horace said, change and progress. And yeah, I agree. That's good. But don't cram everything. I mean, keep it at LDR. The only reason it's MDR is because that church wants more money for that property, and the developers can get more money if they have it MDR. It's just a fact of life. It's LDR. Let it build up LDR. Or apply to the state of Florida for help with the grant to make it a park. Thank you.
Thank you. Next, we've got Tina Lynn. If you'll just come down, state your name and address. As she left for the day. Okay. All right. Chris Kerb, you're up next. State your name and address, and you've already been sworn in. If he comes back in, we'll get him up here. Joshua Zeller. Just state your name and address. Again, you have been sworn in as well.
Thank you. Joshua Zeller, 6506 Lakeshore Neely Drive, Pensacola, Florida. Do we need to swear in again? Or?
We got you already.
So, the lawyer for the church mentioned that, and also I think the staff mentioned that it is a transitional property. So, and like I mentioned before, one of the reasons why we were looking for the MDR as opposed to the LDR, like the lady before me just mentioned, was to be able to address a lot of the issues that the area was having. It wasn't just to be because the developers we had talked to a few developers we had kind of in the past, and no one was that willing to do this work at LDR, just because by the time you do all the infrastructure and build all the ponds out, there's you're going to be underwater as far as your cost. And that's mainly the main reason why we're looking. We were looking for the MDR rezoning, just to be able to facilitate the solutions that we wanted to bring to the area. Plus, bring some of the housing relief to Escambia County. Allow some better pricing for, because as the volume, I mean, I don't have to explain economics to you guys know, but as the volume of houses goes up, the prices will begin to come down and will begin to be more affordable for people that are looking for housing in this area. And with that, that's it. Thank you.
Thank you. Next, we've got Ferdinand Zeller. If you'll please come forward and state your name and address. And again, we had you sworn in under oath, so it still applies here.
Ferdinand Zeller, 7174 Woodside Road, Pensacola. as I said before, I understand the issue of the neighbors. They don't want to have so many houses next to it. But in the other hand, it's a property, as my son said, it needs to be developed. And if it's done like it is now, it's not able to address all these issues. And I see that the neighbors are upset that we bought this property many years ago for building a church, but it's a part of the economy. We have to deal with, like any business, when the numbers are not good, then you can't do it. And that's the reason we moved away from the plan to build a church there, and then bought another church that we can afford. And now, yes, we want to sell it, but as my son said, if it's sold like it is, then the benefit won't be there for the neighbors about this storm issue, storm orders. And in my opinion, the developer really goes out of his way to make an effort to address this problem and to bring a solution to this area. And that's what I want to share.
Thank you very much. And I'll give Chris one last try. I don't know if he's left the building, but okay. All right, so that was our last speaker, unless we've got anything from the applicant or staff that needs to be added. Mr. Sutton.
Thank you. Yes, Rodney Sutton, 120 East Main Street, Pensacola, Florida. I'll make it brief. Thank you for indulging this process. As we understand it, the order is specific so that the development agreement restrictions and the PUD restrictions are effectively restrictions on this rezoning. I just want to say we understand that. We've signed the development agreement so that with this rezoning could not have a contingency if it passes. Those restrictions are already signed off on by us, and we understand them.
And I'd like to add, Mr. Wilson, yes, they were willing to utilize the various tools inside the Land Development Code and the comprehensive plan to try to make the situation better, as stated by, if you see the backup, when this first came. They took on the challenge, they worked with staff, and hopefully to try to make it better for the citizens, not to make it worse, to make it better with various tools that we have. That way it doesn't show up, talk. My name was mentioned twice this morning. I don't have no problem with that. But Mr. Jones is always here to try to listen and to try to be as fair and as transparent as I possibly can. I can't make everybody happy, but I promise you, I'm gonna listen to you, and we're gonna try to make some fair and some sound conclusions and decisions.
All right. Thank you both. If there are any questions from the board, let me know. Seeing none, I'll entertain a motion if someone would like to offer one up.
I recommend approval of Z 2025-04 based on staff's findings.
All right.
Second.
Got a motion and a second. Discussion on the motion. Seeing none, all those in favor, please signify by raising your right hand. All those opposed, motion carries 6-1. That was our last case in the rezoning meeting. We will adjourn that meeting, take 5 minutes if that's okay, Meredith, and we'll get back into the regular planning board meeting.
rezoning script or something, I'll send you a copy of this, cause it's up to type out every time. Only if it's like something that's like extra, it's like 3 words, I might type that out, but, yeah.
And then can you send me all, like, what you read, all that stuff? The staff findings?
Yes, I already have that in the email. I can send it to you.
No problem.
Good.
Thank you, Rachel. Good to see you. You too.
Unless they left.
With a citizen.
All right, we're gonna start back up again. We're gonna run over to the regular planning board meeting for July 1st. Really just left the zoning. All right, so we're gonna start with the small scale map amendment application for consideration, case number SS 2025-04, which requests a future land use change of 4967 Mobile Highway from C commercial to MUS mixed use suburban, as requested by Meredith Bush, agent for Sean Smith, owner. Staff was, this is the correct one in order, right?
Yes.
Okay, just making sure. Staff was notice of hearing sent to all interested parties?
Yes, sir.
All right, perfect. Was notice of the hearing posted on the subject property?
Yes, sir.
Perfect. All right, let's go ahead and get into the overview of the presentation.
Morning, Board. I'm Allison Lindsay, Urban Planner, Development Services. So this is the SSA 2025-04, and this is the location map showing the location on Mobile Highway. This is the 500-foot zoning map showing the current parcel commercial and the surrounding commercial, MDR, and rec. This is the future land use map showing the existing commercial and then the surrounding commercial and mixed-use suburban. This is the proposed future land use that would change it from commercial to mixed-use suburban, and then the surrounding properties. This is the aerial photo of the site. And this is the public hearing sign that was posted on the site at Mobile Highway. And this is just looking onto the subject property. And these are just another couple of views of the subject property. And that's down the little alleyway or drive of the subject property. And this is looking across Mobile Highway from the subject property. It's looking northeast from the property. This is looking south along Mobile Highway from the subject property. And that's the maps and photography. If you'd like me to go into the findings now, I could.
No, we'll go,
Okay.
does the applicant, Meredith, you wanna come up, do you have anything for us?
Good morning, Meredith Bush, 125 East Intendencia, here with the applicant Sean Smith. As you know, the question is whether or not this is consistent with a comprehensive plan. Not in
Have
I'm
you
sorry.
received a copy of the hearing package from staff with staff's
Yes,
analysis? Okay.
I have.
All right.
And, you know, to establish consistency with the plan, you look to the criteria as outlined. We've submitted a report that echoes staff's findings and would ask that you approve the request. Happy to take any questions or address any issues that you find.
Board, any questions for the applicant? All right, we'll move on to staff's analysis.
Okay. Okay, so this is the request to change from commercial to mixed-use suburban. The zoning is commercial. Now, this is a small-scale map amendment requesting to change the future land use of a 2.53 plus or minus acre parcel from commercial to mixed-use suburban. And the parcel is zoned commercial and is surrounded by commercial, MDR, and recreation. So the state basically has three requirements for a small-scale map amendment, and this meets those requirements. One, it is 2.53 plus or minus acres, which is under the 50 acres required. And it does not require a text change, and it's not in the area of critical concern. It already has existing potable sewer, water, and solid waste by Emerald Coast Utilities. There is no wetlands, there's no indications on our national wetland inventory that there are any wetlands on the property. Traffic and transportation, they provided a comment, and they basically have no concerns regarding the proposed small-scale map amendment, and it is noted that their review is solely based on the small-scale map amendment submittal, and when the any of the comments above do not apply they'll have additional comments when they go to the development review process. So the future land use category in the area is commercial and mixed-use suburban, and they do support residential and non-residential development. The change to the mixed-use suburban wouldn't change the area's characteristics while allowing for residential development. This site it appears that the business that we saw in those pictures has been there at least since about 2020. Our records do indicate that this was Bob's Trailer Court back in the 1990s. The applicant is asking for a change in the future land use from the commercial to mixed-use suburban so they can have residential development. And that's all of staff's analysis if you have questions.
Okay, thank you. Any questions for staff on this one? All right, perfect. Move over into public comment. Sean Smith, you want to come up and speak on this one, or?
If you ever have any questions, sure.
Okay, all right. Lori Abel-Wall, I believe I'm saying that right.
Hi, I'm just a concerned.
If you can state your name and address.
Oh,
please.
Laurie Abdelwahed, 193 Talladega Trail. I'm just a concerned homeowner on the street of Talladega that runs right up. I'm 2 houses away from this development, and I'm here just to get some information and find out what is going on. My understanding, if I didn't come to this one, I couldn't come to future.
This isn't a quasi-judicial, so it
Oh,
would be free to
okay.
speak, yeah.
So I'm here just to try and get some information on what is going to happen with the property.
Okay, thank you. Next speaker is Vicki Evans Spatz.
Vicki Evans Spates, 199 Talladega Trail. My property is right next to this property. As Lori said, we're just here to try to find out what was going to be developed right next door to me.
Okay, thank you for coming up. And then next one is Terry Malaya.
Good morning. My name is Terry Millie. I live at 200 Talladega Trail, and I am on the south side of this property. And I'd like to know, is this going to be a mobile home park?
It's not gonna be parked.
It's not going to, are you going to put mobile homes on there?
Plan for 4.
For 4. Okay, because it was a mobile home park before, and we had all kinds of vandalism from people that lived there. So if that's what it's going to be, I am dead against this happening here. So, yeah, you understand that, but they come onto our property. I mean, he's done a great job cleaning it up since he's bought the property. I think there were 30 some odd mobile homes there. He's cleaned them all out but one, and he's brought another one in. But he's cleaned it up. He's put in sewers. He's put in a fence. So I can't say he's done any destruction to the property. It's people that come in with that environment that we're concerned about, because we have been broken into. They come on our property, and I'm against this. But thank you.
Thank you so much, ma'am. I believe that it concludes public comment. All right, is there anything further from staff or the applicant on this one? Mr. Chair.
I just like to clarify that with the change in the commercial to the mixed-use suburban, at this particular point, they could not do anything except for commercial if it was a predominantly commercial development. So because it is commercial zoning and commercial future land use, changing it to the mixed-use suburban will allow not only the commercial, but it will allow some residential component.
I was going to ask the applicant if he would like to shed light to his neighbors what intended purpose is. I know we can't hold him to that, to the... Or Meredith?
Thank you. So the applicant doesn't have any current development plans, other than maximizing the value and potential of the property. This may very well increase the development by 4 units, and he's happy to speak to the neighbors. The fact that it could entail mobile homes is not a criteria for your consideration, so we've just asked for approval.
And I'll put it out there for the public, you know, every development in Escambia County for this type of property or what it would be developed into would have to go through the DRC process, which would go through planning department and such like that. So there's always other venues, when it does come up, that you can keep aware of it.
And I would like to add, because there was one about the mobile home park. I like to be clear, Meredith, just to remember what Meredith said. That zoning category, it does allow for mobile home parks, correct? So I want to be clear that the possibility of that can happen along with the other uses that are allowed in that zoning category and that proposed future land use category, since some of the neighbors raised that. I'd like to be clear for the record, so it was what they told me and could not. The possibility is always there.
Just as sort of said there. If there's nothing else on this board, I'll entertain a motion.
Motion to accept as proposed.
All right, we have a motion. Do we have a second?
Second.
Motion and second. Any discussion? Seeing none, let's go ahead and raise your right hand if you approve. 2, 3, 4, 5, 6, 6. All right, we have 6 votes in approval. All right. Motion passes. We'll move on to the next one. Didn't prepare today, so. All right, we're moving on to the next one, which is a small-scale map amendment application for consideration for case number SS 2025-05, which requests a future land use change of 700 Geis Lane A from C commercial to mixed-use suburban, or mixed-use urban, sorry, as requested by Meredith Bush, agent for Tanvi Group LLC owner. Staff was notice of the hearing sent to all interested parties.
Yes.
All right. Was notice of the hearing posted on the subject property?
Yes.
All right, now we'll move over to the presentation for you.
Okay, so this is the small scale map amendment 2025-05. This is the location map showing the property off of Geesey Lane. This is the zoning map showing the current zoning and the surrounding. This is the future land use of commercial and the surrounding of mixed-use urban. This is the proposed for the future land use mixed-use urban. And this is the flood zone map. And this is just an aerial site of the property. This is the public hearing sign that was posted on site. And this is looking east from the site. Looking east onto the site. Looking along the property's southern boundary, looking south along Geesey Lane, looking north along Geesey Lane, and this is looking west across Geesey Lane from the subject property. And that's the maps and photography.
All right, thank you for the presentation. Any questions on that, guys? All right. Would the applicant or the representative please come forward?
Meredith Bush again, 125 East Intendencia. Much like the last case, we're seeking to go from commercial to mixed-use urban. We've prepared a report, submitted it, believe we meet all the criteria of the code and comprehensive plan, and would ask for approval. Happy to take any questions.
Okay, and also as well, you received a copy of all their stuff. You're good to
Yes.
go? Yeah. All right, then let's move over to staff analysis unless there's any questions for the applicant at this time.
With nobody here to speak, do we, and staff agrees to everything, do we have to go through the analysis, or can we still have to go through
Okay,
analysis?
no, perfect.
We can,
We're good
You
for
don't
that.
have to
I
go
always-
through it.
We can expedite.
I always try to give it, hey, if you guys say to do it, I'm gonna do it. All right, well, we'll go ahead and expedite if there's any comments from the board.
I would like to approve SSA 2025-05 as staff has provided.
Second.
All right, we have a motion and a second. Any discussion? Seeing none, go ahead and raise your right hand if you want to approve. 2, 3, 4, 5, 6 votes per approve. Motion passes. And that one closes out that case. And then I guess we have any action items. Let's see there. No one for public. Let's see there. Director's review. None. No county attorney's report. All right. Scheduling of future meetings. Next meeting will be Tuesday, August 5th at 8:30. So we'll see you then. I appreciate y'all. Have a great 4th of July.